morning, Your Honor.
We're still waiting for counsel on a couple of other matters that we have to take first, so we're going to proceed to normal course. Seeing Mr. Hamlin present with us in custody. So bench warrant return. I know you needed an opportunity to be able to see what we have here. It was a sentencing failure to appear.
And Your Honor, I've spoken with Mr. Hamlin. We've gone through his PSI. I think we're comfortable going forward today, Your Honor is.
I'm prepared with the sentencing information to proceed today. We had, of course, with the original guilty plea agreement, no up to probation. If there were no prior felonies or gross misdemeanors, the PSI indicates that there were, in fact, prior felonies, but regardless, this date would have been reinvested with the right to argue based on the failure to appear at sentencing, so I'm anticipating hearing the state's argument, and we'll come back and hear from the defense, okay?
Thank you, Your Honor. And yes, pursuant to the negotiations, the state does retain the right to argue. The defendant not only has a prior felony, he in fact has 4 prior felonies, and a 2011 misdemeanor assault. In fact, P&P recommends a 12 to 32-month prison sentence. His co-defendants in this case, specifically Mr. Ramos, received a 12 to 30-month sentence, and co-defendant Roberts received a probation. However, he has received a probation violation as recent as this month. So with that, Your Honor, I would ask that the court impose P&P's recommended sentence of 12 to 32, and I show 49 days credit for time served.
All right, thank you. Ms. McNeil, or should we hear from Mr. Hamlin?
Do you want to speak?
Mr. Hamlin, would you like to speak on your own behalf this morning? You're certainly entitled to do so. This is your day for sentencing.
Yeah, I would just like the opportunity to start this the right way, because I got out of here with no money, no home, and when I was released, it was all downhill. But I actually, in the past month and a half, I came out and I got a job, got a place to live, and everything was looking better.
And Your Honor, I understand that Mr. Hamlin has the 4 prior felonies. However, they are from one case from 2006, which was 10 years ago. When I met Mr. Hamlin when he was first arrested on this case, he was very distraught. He had just moved to Las Vegas. He had a job that he was going to start, and he had everything that he owned his entire life in the room that was searched by the police. I understand that Mr. Ramos' co-defendant went to prison, but it was Mr. Ramos who was the reason that the room was searched. He had an active warrant out of Colorado for drugs, and it was noted that he was possibly armed and dangerous. Mr. Hamlin was in the room with him. This is a room that Mr. Hamlin was in, that he did not know Mr. Ramos very well. The reason that Mr. Hamlin's case and Mr. Roberts' case were negotiated the way they were, different from Mr. Ramos, is because they had a better mere presence defense than Mr. Ramos did, because he was the one who had the warrant for drugs. Mr. Hamlin lost everything while he was in custody. There were many times that I would visit him during the course of my representation before he was released where he was just distraught. He had moved here to turn his life around and lost everything. He took this deal, he got out of custody, and then he indicated to me that he was sleeping in a dirt lot because he had lost everything. The first night he was out of custody, the little that he had with him was stolen from him. To his credit, he turned himself in on this warrant. He wasn't arrested on a new case. He knew that this was outstanding, and he turned himself in to take care of it. He now has a job again at Auto City Customs on South Polaris. He has a place to live. He is again putting himself back where he was before he was arrested on this case. So I would ask Your Honor to consider the fact that his convictions are older, that this is a man who is trying his best to put himself in the position we would like to see people putting themselves in, and consider still giving him a grant of probation, Your Honor, and I'll submit it on that.
It is difficult in a situation where someone actually turned themselves in on a warrant to not, from the outcome of the sentencing, appear to recognize that fact as being a positive. It is absolutely a positive, and depending on other circumstances, I very well might have considered giving another opportunity or an opportunity for probation. When I say another, is because the original negotiation would have contemplated probation with a much heavier underlying sentence if there had been a violation. Essentially what has happened, Mr. Hamlin, through whatever circumstances you controlled or that occurred, you sort of violated your probation before you were ever placed on it by failing to appear for your PSI and by failing to appear for your sentencing. The outcome, had it been after sentencing, would have been you serving a 2-5. I'm not going to impose a lengthy sentence on you. In fact, I'm going to impose the minimum sentence on you, but I am going to impose a term of incarceration because there is clear indication here, even with these older prior case, what we have here is a situation where you're in crisis and you are not stable, and there's no indication that I would have here that you would complete successfully a probation grant. And that's really what those things are for. What you can do, and what I will recommend you for, and I think the age of your prior felony hopefully will not preclude you from it, is if you are incarcerated for the minimum sentence, you get treatment while you are there, you do programming while you were there, all of those things to give you the stability that you just told us you didn't have when you came out of jail before. If you do all of that, then you can apply for what's called the 184 program. And that 184 program gives you potential for housing, potential for treatment, potential for services, other things. If you don't do the program and you won't be eligible for it, that's your choice. But at this point in time, I cannot justify giving you an opportunity at probation with these circumstances before me. But what I can do, again, is I can give you what is relatively the minimum sentence, actually less than what's recommended in the PSI slightly. I'm going to adjudicate you this time guilty of conspiracy to violate the Uniform Controlled Substances Act. I'm going to sentence you to a minimum of 12, maximum of 30 months in the Nevada Department of Corrections. I'm going to impose a $25 administrative assessment fee. It does appear that DNA still needs to be taken because these other matters were another state. So I'm going to impose the DNA payments of $150 DNA analysis fee, $3 DNA collection fee, and with the nature of the charges, we also have a $60 chemical and drug analysis fee. You have to pay those fees, and you have, according to the PSI I have, is 50 days credit for time served. Does anybody have a different calculation based on other time you may not be aware of?
Yes, Your Honor, he was arrested on the warrant on May 9th, so I think it's 56 days credit.
Yeah, I think I had from the 10th to the 16th, so that I was counting those days, but maybe there was another time. Do you have 56 as well?
Yes, Your Honor.
56 days credit for time served.
Thank you, Your Honor.
All right, thank you. Good luck, Mr. Hamlin. I hope you'll apply for that program. All right, we'll come back to that. Bottom of page 4, I have State of Nevada versus Andrea Niles. Seeing Ms. Niles present in custody. This is for a termination from drug court. This is a public defender matter, but we also have an officer present. Good morning, officer.
Good morning.
And as I said, Ms. Niles is with us present in custody. We have the further proceedings termination from drug court. We also have the revocation report on file, so it is on calendar for both. Are parties ready to proceed?
Your Honor, if we can go ahead and trail the matter briefly, I think I thought it was just on for the further proceedings. This is Ms. Miles' case, but I believe I can go ahead and get it resolved.
Do you have a minute, officer, to talk to Mr. Gutierrez, see if this can be negotiated? All right, we'll see if we can get this resolved. We recall it. I do just want to note, I want to make sure that no one is here on the matter on the top of page 4. That is State of Nevada versus Gustavo Gutierrez Chavar. Are you here on that matter? This matter was placed on the calendar as an alternative date to a prior date, and then the parties actually spoke with each other and continued the matter into June. So I'm sorry that you did not, I have that right? It's a June date? That's right. So I'm sorry that you did not get the information that it should have been off calendar. By the time we found out, it was too late to pull it off the calendar. But now our new date, I believe, is going to be, is it this June 1st? June 1st.
Thank you.
For this matter. If you can return on that date, we'd very much appreciate it.
Thank you.
Oh, well, we have another interpreter matter. Maybe we can call that now, and if the parties are ready to get you out of the way.
Oh, I don't think so.
Okay, and he left us again?
Yes, he went.
Okay, well, we'll recall you when we see you. Thank you. At the bottom of page 9, State of Nevada versus Jamal Carr. We have counsel.
Judge, I'm here for Sean Sullivan.
Oh,
And
you're
I think it's with Hetty's case.
This is Jamal Carr. This matter is on calendar for 2 matters. Defendant's motion to suppress and defendant's petition for habeas corpus. Are you actually going to be arguing for?
No, Judge. I think they agreed to getting a new date, and I just had Mr. Sullivan left for another court up in North Las Vegas, And I believe that was already discussed, right? The new date.
Judge, it's
regarding-
not just about getting a new date, basically. we
I was
would
gonna say,
have to
nobody told the court, so.
Yeah, no,
we're
we
here.
would have to hold an evidentiary hearing to decide the motion as well as the petition, so we weren't expecting to be
So
arguing
we were
today.
just thinking we would go ahead and set hearing date.
Correct.
Now, are we intending to address the motion to suppress separately from the petition, or we want to hold a hearing date for both?
For both, because it's the exact same issue.
Well, it appeared that way to me as well, but then, you know, different standards, different situations, I wasn't sure. It's a little tricky this month in terms of hearing dates, only because of the stacked up evidentiary hearings we've ended up with already on our Fridays, plus we're coming into our civil stack. I'm not sure what
Actually,
our
that
trials
won't
are.
be a problem for the parties. Mr. Solomon and I have agreed to kick the evidentiary hearing out till August, which I know takes us past our original trial date, but again, both parties have no objection to then reset the trial at this time as well.
Well, that gives us very, very much more flexibility.
Yes.
I right now could give you, I typically like to do these hearings on Fridays, just because if I have to build a trial around it, I could do that. And I have the I have the 19th, just let me see, I have the first Friday in August, which is the 5th. I'm already booked on the second Friday in August, but then I have every other Friday in August after that for the hearing. So is there anybody that, is the 5th okay, or is that, do we have?
Can we go one more week out?
Well, the next
Or
week
me.
is I already have an evidentiary hearing on the 12th, but I could do the 19th.
The 19th would work for me.
We'll say August 19th, and then what I'll do is I'll close off, because I have that scheduled potentially for business court settlement conferences, but it hasn't been used yet. So we'll close that off, we'll set you at 9 for this, just in case we end up with trials, and then we can give you whatever time that day would be necessary, okay?
Okay.
And then as you indicated, that date that's been agreed upon to continue the motion to suppress in the petition for habeas corpus will also be after what is currently our calendar calling jury trial date, so we just need to move you to another stack. Can you remind me, since I don't have that information in front of me right now, whether or not this one would be overflow eligible?
It would be.
It would be, okay. I'll just let my clerk take a minute to see what options we have then for replacement of this trial.
Calendar call, September 7th at 9:30. Jury trial, September 12th at 10:30.
Thank you, Your Honor.
Thank you both.
Thank you, Judge.
Do either of you have anything else this morning?
No, Your Honor.
Okay, thank you. Okay, Mr. O'Gara, I guess you do have another matter we're waiting for Mr. Chen.
Yes, we're waiting for Mr. Chen, I believe.
Okay. Mr. Local, what do you have?
Your Honor, it's, let me see here. 1 Baker, bottom 1, Mark Feinsod, Your Honor.
Yes, thank you. Standing by versus Mark Feinside. Now, this is on as being an interpreter meet as well.
No, that's incorrect. He's not even present, Your Honor.
Yeah, it wouldn't be present, but okay, I don't know why that's got that.
Yeah, it doesn't make sense.
Maybe we need to look into that and see about removing that. Motion to amend judgment of conviction pursuant to the guilty plea agreement, and of course, that would be a situation where he had been on a discharge. We know that from back in February. We reviewed that. We can grant the motion, but typically we would have the person in here to withdraw their plea and re-enter their new plea. Did you?
He's on the East Coast. I think he's in Miami or Florida. He
It's a
has.
gross misdemeanor. Did he give you authority
He
to
did.
enter his plea today?
Yes, Your Honor.
State have any objection to us going ahead and allowing Mr. Whipple to stand in for Mr. Feinsod on a gross misdemeanor to enter a plea?
No, Your Honor, and it's my understanding that the restitution has been paid in full.
I appreciate that representation too. That was going to be my other question, but it does appear that he is in a position now to have been honorably discharged with restitution paid in full. Again, the records reflect that the honorable discharge took place on or about February 4, 2016. He is entitled pursuant to the guilty plea agreement to withdraw his original plea, which he entered in one count of attempt burglary, and now enter a plea to conspiracy to commit crime gross misdemeanor, based on Mr. Whipple's representations that he has authority to enter that plea and then receive credit for time served. I'm not going to go through all the motions that I would go through on a typical plea entry. I'll just ask you, Mr. Whipple, can you give us just some specific representations of when you spoke with him and that you got the authority? And
Oh, Your Honor,
He's constantly in contact with you, is he?
He became my best friend after this case, Your Honor, and it always is based on need. I know right now he's in the process of getting a job, a teaching job, and that he has contacted me multiple times in an effort to get this matter filed and get the felony reduced to a gross misdemeanor. I don't have a specific date, though I could probably get it because he texted me as well. And if I pop in his name.
That's okay. I just wanted to get a few representations about when you had your communications and the fact that you're going to enter his plea today. So we'll accept your representations that you have authority to enter a plea to conspiracy to commit a crime of gross misdemeanor. I'll then go ahead and continue with the sentencing. We don't really need a gross misdemeanor worksheet because we understand that the outcome from the original plea deal was that he would get credit for time served. I'll just give the credit for time served and we'll close the case.
And I specifically have a text from him on February 22nd at 8:23 a.m. requesting the same.
Okay. Thank you.
Thank you, Your Honor.
Thank you for being here today. Do you have any other matters?
No, Your Honor. Thanks so much. Have a good day.
You too. I have an officer present on the top of page 5 for a revocation matter in the state of Nevada versus Carnell Thomas. See Mr. Thomas present with us in custody. Mr. Gutierrez. Sorry, did we interrupt your negotiations or
No.
your timing for this one?
No, we're good. I want to go ahead and note that I already talked to the state about this. I think there's been an error. I don't know if you want the state to go first or me, but I don't think we should be here for a revocation.
And Your Honor, I think Mr. Gutierrez is right in that I think that there might be some confusion and we're actually going to look to the court for some clarification.
Okay.
It appears here in this case that the defendant entered a guilty plea agreement whereby he would plead to the felony in this case and be sentenced to probation, and the only condition of probation being 6 months in the Clark County Detention Center. Upon being released from CCDC, he would receive an honorable discharge. However, it appears from the state's notes that when he was sentenced back in August of 2015, he was sentenced to probation with 6 months CCDC, but he was also placed on a 12 to 30 month suspended sentence with probation not to exceed 3 years, which is also reflected in the judgment of conviction, which was subsequently filed. So I'm not sure if the defendant was relayed information that upon the termination of his 6 months of CCDC, he was to then report to PNP to finish his probation, or if he was informed that he would then be done and a reporting would not be necessary at that point.
And if I may, Your Honor, my understanding is obviously if he's adjudicated guilty of a felony, there has to be an underlying sentence imposed regardless, and so that's why he got the sentence he did. In order for him to get probation, you had to order probation. You ordered a term of probation, but then you gave one condition of probation, that means 6 months CCDC. So as soon as he completed the 6 months, every requirement was done, and he would be ripe to receive an honorable discharge. I mean, to
Technically, there were
receive.
2 requirements because he had to pay the $25 administrative assessment fee, just to be clear.
That is correct.
We can see from our records that we did not order any other terms and conditions of probation, but, you know, the irony is the wrong word, but you're all looking at me for guidance on this. I don't have any clue how any of these things work when it comes to the post-sentencing handling of this. I don't remember this particular case specifically of having this conversation, but I know I've had conversations in cases where the deal is to just serve a term in the CCDC and then let the case be wrapped up, whether or not we need to have an underlying sentence, whether or not we need to have these components or not. And I take those representations at face value. I do the sentence in the spirit of what the negotiation is in hopes that the outcome will actually match up to what the spirit of the negotiation is. But you know what? That doesn't always work. So at this point, from what everybody is saying and from what I can see, if in fact, you know, when I saw this come on the calendar, I thought, well, what happened? Did he get released early and somehow he didn't complete his 6 months and something else get in the way? But if what everybody is telling me is that he did in fact complete his complete his 6 months in CCDC, which was his 1 of 2 conditions of probation, then he should be able to receive an honorable discharge. But I guess what I really need is I need guidance either from the officers with us here today, or I can contact the supervisors over there at PNP to find out how should we have structured this otherwise to avoid this confusion and this inconvenience to Mr. Thomas based on what the court intended the sentence to be. Because there's no probation conditions, there's nothing else to do. I do appreciate the underlying sentence, but the intention of the negotiation was that after he completed 6 months, he would be honorably discharged, which would tell me that parole probation, all they would do is do their paperwork to allow me to sign off on it to honorably discharge him, but that apparently didn't occur.
Yes, Your Honor. I have experience with a couple of cases where under the sentencing guidelines, the judge would put there, upon completion of the 6-month sentence or 9-month sentence, subject will be released from custody, basically.
Well,
So we didn't see it on the sentencing
I
here.
mean, I believe that's what was said in court. That certainly was what we understood to have been negotiated. That's what's in the guilty plea agreement. Typically, we repeat those things in court. If we neglected to see that in the language of the JOC and signed off on it, then we take responsibility for that, obviously. But certainly that would have been the negotiation, that would have been the discussion, and that should have been something that everybody was aware of. But at this point, what's the fix? Can we get the honorable discharge paperwork, and can we release Mr. Thomas, and can we consider this completed? Do we have to actually re-adjudicate? I would hope not, but I mean, we just amend the JOC, or what's the fix?
Well, Your Honor, I think that at this point, what's reflective in the GPA and what appears to be reflective in the DA's notes would be that he was to receive an honorable discharge after completing the 6 months in CCDC. If he has in fact done that, then yes, I think that an amendment to the JOC would be appropriate to just reflect that he's now getting the honorable discharge after having served the only condition, which was the 6 months, so that there's not any additional requirements set of him reporting to PNP.
Well, here's where it could get tricky. Mr. Gutierrez, you can give me some information on this too, is I think CCDC released him with some good time credits or some other considerations short of 6 months, because I've got, at least according to the violation report, I know the sentencing took place on August 31st, and according to the violation report, he was released from CCDC on January 5th. That is not 6 months.
Correct.
Right, this was not 6 months flat time, it was just 6 months regular time. And so on a term of 6 months, CCDC with
Well,
the...
that's the part where that's not necessarily clear from either the negotiations or from what the court said. It said that the state has no opposition to probation with the sole condition of 6 months in the detention center. I don't recall there being discussion of it being flat or regular, and of course, apparently it neglected to be something the court recognizes not being in the JOC at all. So, I mean, at this point...
And Your Honor, if I may, it actually does reflect in the JOC that the defendant must serve 6 months regular time
Okay.
in the Clark County Detention
Well,
Center. It does
I'm being
reflect
told, I
that.
don't have it in front of me, and I'm being told it wasn't in there, and that's why PNP didn't recognize it. So that's where my confusion comes in. I don't have the JOC in front of me. I wouldn't have needed it for today's purposes, but...
Right.
So again, I'm still not quite clear where the disconnect is, but we will ensure that we're more clear on these things in the future. At this point in time, is the state in agreement then that the ultimate outcome here was regular time, that the 6 months has been served, and that we can have an honorable discharge?
Yes, Your Honor.
All right, so then what we need to do is order Mr. Thomas released, and then we need to, and my clerk will fill out the paperwork to effectuate that. Obviously, that'll happen in whatever normal course will happen today. Our apologies to Mr. Thomas for the inconvenience of there being something that indicated to parole and probation that there should have been a report. And, you know, at this point, it was a different negotiation than we typically see. And I think the confusion is understandable, but at the end of the day, we need to sign off on the honorable discharge paperwork, get Mr. Thomas completed, and let this thing be wrapped up.
Thank you very much, Your Honor.
All right. All right. I'm going to call the matter now on the top of page 2, State of Nevada versus Brenda Stokes Wilson. This matter is on the sentencing today. Is there any legal cause or reason why we cannot proceed with sentencing?
No, Your Honor.
No, Your Honor.
I would note that Ms. Stokes Wilson is present with us in custody. I understand that we do have, or we have previously received notices of witness speakers. Mr. Turner, can you advise us what speakers we have this morning?
Yes, Your Honor. It's my understanding that there will be 4 witness speakers. It will be Tawana Reeves, the mother of Jade Morris, Philip Morris, her father, Brenda Morris, her grandmother, and Claudette Jones, the grandmother.
All right, so for the speakers that are here with us today who may not have been present in the courtroom previously on a matter in which we had speakers The way we will proceed is we will hear from the state if the state stands by the negotiation as originally entered. I will then hear from the defense, both counsel and Ms. Stokes Wilson, if she wishes to address the court. At the conclusion of those discussions, I will then invite the speakers to come forward. I'll allow Mr. Turner to call the speakers in whichever order. Perhaps that will be the order. If it's a different order, that's fine. We will hear from the speakers, and then the court will render its determination on the sentencing. All right? And I just want to make sure that everybody stands. At the time for the speakers to speak, they can go one of two places. They can be there at the council table next to Mr. Turner, be sworn by my clerk, and give their testimony from that location. Or if they wish to come up to the witness stand, they're welcome to come up to the witness stand, be sworn by my clerk, have a seat, and testify from there. And of course, the information that we are looking for from the speakers and what the statute contemplates is the impact of this circumstance on you, yourself, or family members. It is ultimately the court's determination as to what the sentence will be. And this is the situation to discuss with the court, again, these impacts on family. I will first ask the state, and Mr. Turner, does the state stand by the negotiation?
The state does, Your Honor. The state would ask the court, and I will keep it brief in light of the stipulation, Your Honor. I'd ask you to follow the stipulation of the parties that we went into great detail in the guilty plea agreement to impose life without the possibility of parole on first-degree murder, the maximum sentence on the deadly weapon enhancement for that first-degree murder, as well as consecutive and maximum times on remaining counts. Judge, I know the court's aware of the facts of this case, and I would only like to point out that nothing is alleged by the defendant, either in interviews or anything else, could justify what she did to Jade Morris on that day in terms of the torture and mutilation of Jade, leaving the butcher knife inside of her neck for her father and family to find over the Christmas holidays. She knew where her body was, and yet she failed to provide that information so that that family could suffer all to get back at Phil Morris for some perceived slight, including slashing the face of Joyce Rhone, who was also victimized in this case, a friend of the defendant. So I'd ask the court to follow that stipulation, and I'll submit it.
Thank you, Mr. Turner. Mr. Orm, do you wish to speak first, or does Ms. Stokes Wilson wish to address the court?
I believe Ms. Stokes does not want to address the court today. She wants to remain silent. Is that correct?
I would note that Ms. Stokes did give her agreement to your statement that she does not wish to address the court. If after Mr. Orm speaks, Ms. Stokes, if you would like to say something on your own behalf this morning, you are welcome to do so. This is your date for sentencing. You are certainly also with the right to not speak if you choose not to. I'll just check back in with you after I hear from Mr. Orm at that time.
A couple of house cleaning matters, Your Honor. First of all, on Friday, Ms. Stokes indicated to me that on her pre-sentence report, it indicates her name is Ms. Brenda Stokes Wilson. She wants it just to reflect Brenda Stokes, if that's at all possible.
I have also known as Brenda Jean Stokes, and typically the caption, it's not at all uncommon that we will have captions that reflect one name as the primary name and then an alternative name, which is some version of that name as well. We typically don't change the captions in order to make a change as long as one version of the name appears there, and because one version of the name does appear there, I will leave the caption as is, but we will note that and refer to Ms. Stokes as Ms. Stokes as we proceed.
Thank you, Your Honor. Ms. Stokes has respectfully requested that I take the time to tell the court a little bit about her. She recognizes that she is in a very bad situation. She also has heard a lot of information that is very negative about her, and she wants people to know a little bit about her background. So I know that there's a stipulated sentence, but I like to take a few minutes at my client's request just to inform the court and the state what kind of an individual this was up until this time and since that time, Your Honor. We provided a sentencing memorandum to the court which was sort of startling. A lot of the good work came from the Special Public Defender's Office, and what's sort of startling about this is when you look at Ms. Stokes' background, her childhood, it almost seems like something that occurred in the 1800s. She was raised on a plantation in the South. Her father had been raised on a former slave plantation. We provided a picture to the court of where she grew up. She had burlap clothes, tremendous poverty. She witnessed things on that plantation that were just truly horrible. There were dust croppers that went over constantly and caused sickness and illness to the people there. She lived in an incredibly impoverished background. Her father was abusive to her, very, very abusive to her, and she grew up watching her father, who had been a professional wrestler, beat on her mother and beat on her siblings and beat on her. At some point, Brenda sort of became the person who had to take control of the family in terms of standing up for her other siblings who were beaten constantly by other children, beaten by the father. And Brenda did the best she could to stand up to an adult male. At one point, police were called, shots were fired by the father against Brenda. Her life growing up was very, very difficult. But out of that, Brenda continued to work. She got a job at age 15. She worked very hard and tirelessly to assist the family. At one point when she got a paycheck, she actually thought, for the first time, my siblings can have Christmas presents. She bought Christmas presents for the family. That enraged the father. The father began beating people in the family, began threatening Brenda. It truly was just a really horrible upbringing for Brenda, but she came out of it, and she went to airline school, and after that she worked in a casino in Biloxi, Mississippi. Eventually she came to Las Vegas. And what is tremendous about Brenda is the letters in support of Brenda, where one person describes how she had a child who had leukemia, and Brenda helped that child, helped the child all the way through death. And then when the funeral came, Brenda was at a car wash. It was a charitable car wash to pay for funeral expenses. And the lady expresses to the court how Brenda never asked for anything, worked there for 7 hours, took the lady back home, helped, and never asked for anything. She was a very charitable human being. That was reflected by her pastor. That is being reflected by all of the people around her. Because Brenda really was a role model. And I know that a lot of people in the courtroom probably think, well, is this woman really a role model? Look where she stands today. I think what Brenda Stokes had hoped for is that people could stop and think to themselves, up until the moments before this happened, what kind of a human being was this? It really was a very good human being. And I think what really proves that, beyond any doubt, is that people should recognize that Ms. Stokes has 3 children. She came from being raised on a slave plantation. And one of those children, her oldest, Brittany, wrote a letter to the court, and she is now working in the TV industry. She works for NBC, or had worked for NBC, and now is in San Diego working in that industry. And she describes to the court how her mother was an amazing role model, and that she didn't see the signs in her mother. She wished she had. As she looks back, she recognized her mother had had a hysterectomy several months before these incidents, and that she was suffering from some type of depression. But she really credited her mother with giving her everything. And even when Brenda didn't have money, she'd take the money she did have and put it so that Brittany could go to cheerleading. That was important to Brittany because she became a UNLV cheerleader. She really has done well. Her other 2 children also went to college. And that's a real credit to Ms. Stokes. And I think she wants people to know that she was a good and has a good heart. And I think that seems like a contradiction, because we're all standing here, as I heard Mr. Turner explain, the horrific nature of what the court has before it. But Ms. Stokes desperately requested that I take the time so that people could hear this about Ms. Stokes, that she hopes to take the rest of her life that she knows will be in prison and try to give guidance to the younger prisoners. I think Ms. Stokes will be able to do that. Shortly before this incident, she had sought out medical help and described that she felt that she was going to hurt someone and that she really, really needed medical help. And that was on December 14th. She visited Dr. Howard Coker, and according to his notes, this is a 50-year-old female, states mentally her life is bad. She feels like hurting others. She's unsure if she wants to take her own life. She feels that she should be in a facility. She wants to wait until after Christmas. Her family will be in town. unfortunately, she did not get the help that she needed. It was incumbent upon her to push forward and try to get that help. She didn't, and she's in this situation. But if you look at a young lady who had dealt entirely with adversity in her life and the good things that she did in the community to helping numerous charitable organizations and raising 3 really fine children, she's been a good daughter, a good mother, and unfortunately, she has made some absolutely atrocious decisions that I know Ms. Stokes truly feels remorse. And it's hard for her in front of the world, the cameras, to express that to the court. But it was very important that I stand here before you, Your Honor, and address those matters so that people can think that it's not just a monster, something's gone wrong. But for many years of her life, she just really, really tried to be a very good, law-abiding, God-fearing human being. With that, Your Honor, I would ask that you follow the recommendation I submitted.
Thank you, Mr. Oram. And Ms. Stokes, as I indicated, I would check back in with you. Do you have anything that you would like to add for the record this morning? No, Your Honor. All right, thank you, Ms. Stokes. Mr. Turner, then, I have, in whichever order the speakers would like to come forward. Where would you like to be, ma'am, at the witness stand? Or, when you reach the stand, you just go ahead and remain standing by the chair. Okay. You can put your belongings down, that's fine, but just remain standing, and the clerk here to my left will swear you in. It's okay, if you could just say your name for us and spell it for the recorder for our record, please.
It's Claudette Jones. That's C-L-A-U-D-E-T-T-E. Last name Jones, J-O-N-E-S.
And Ms. Jones, whenever you are ready to proceed. That's okay. I don't know anybody who is.
I'm Jade's maternal. Defendant, and she came behind. She was quite a few years behind her brother and sister. And I just want to know that she was a beautiful child. She was a straight-A student. She was a child that any parent would be proud of. She was kind and I'm sorry, I thought I had better control. And I can understand the things that happened to this young lady, but there was no reason ever to take a 10-year-old out and just brutally. She didn't have anything to do with grown-up problems. And to have done this, there is no excuse. We all have had hard times in our lives and have had to overcome something. But there's never an excuse that Jade had to lose her life. She trusted you. She loved you. And we trusted you with her because of how she felt. And to have taken her out and done this to her is just the worst thing that could have ever happened. Just before Christmas, and she was found on my husband and my wedding anniversary. This is what we have to live with for the rest of our lives. Her 20-year-old brother was so devastated by it. We lost him 5 months later because he just could not wrap his mind around what had happened to his sister. I hope you go to prison and you think about what you've done every day. I don't know how, I know everything about your children, and I don't know how you came to a place in your life where you could do this at 50 years old and leave your own children behind. I don't understand. But I do hope you do good things in prison with your life. That's all I can say.
Thank you, Ms. Jones. Just mind your step as you exit the witness stand. You're welcome to retake your seat. Did you get yours? Thank you. Will the next grandmother be speaking? Would you like to be in the same place? Yeah. It's just the same thing if you could remain standing when you reach the chair.
Testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Please be seated. If you can please state and spell your name for the record.
My name is Tawana Reeves. It's T-E-J-U-A-N-A. Last name is Reeves, R-E-E-V-E-S.
Whenever you're ready, Miss Reeves.
Well, 3 years ago, I was lied to. I thought I was letting my daughter go with someone that cared about her, that she cared about. And the last words to my daughter were, "Have fun, I love you." Those words haunt me to this day because Jade didn't have fun. Jade was taken out and killed like a wild animal and left with a knife stuck through her little body for 6 days. And we just sat in agony, not knowing where she was. And someone knew. They could tell us. Okay, at least if you tell us now, maybe we can get through the pain more. But there's nothing like sitting and not knowing where your child is and knowing who the last person she was with. So every day I live with this pain of those last words to my child and knowing I will never see her grow up. I will never see her graduate from high school. I will never see her follow her big sister around like she used to. I will never see any grandchildren from her. And this pain will never, ever in my life go away. Sometimes I cry like it just happened yesterday, and it's been 3 years. And I just would like to know why. What could she have done so bad that would make a 50-year-old woman kill her like that? I can't understand it. And there's no excuse or reason that will ever excuse it. I have recordings and photos that I have to remember my child by. And the last recording she left in my phone was she sang me a song, she read me a book because she loved to read, and she said, "Mommy, I love you." That is the only way I will ever hear her voice. And I wish it could be played for you every day of your life so you can remember that sweet little girl that you killed like a dog.
Thank you, Ms. Reeves. You may mind your step, please, as you exit the witness stand. We have 2 additional speakers. Is Mr. Morris going to be next?
Yes, Your Honor.
Mr. Morris, would you like to stand with counsel table, or would you like to come to the stand? Looks like you're going to the stand. So please, when you reach the chair, please remain standing, and my clerk will swear you in. My clerk is here, Mr. Morris.
You solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Sir, if you can please state and spell your name for the record.
Philip Morris. Philip, P-H-I-L-I-P. Morris, M-O-R-R-I-S. Jade is my world. And I used to always tell Jade, how was I ever so lucky to get a kid that is just so amazing. Jade cared about everybody. Didn't matter what she had, she shared it. Kind would be being told to be in the grocery store and she seen a baby and it needed the diaper change. This is at 4 years old. She asked me if I would allow her to change the baby's diaper. This is at 4 years old. My baby was already reading at 2 years old. She was just phenomenal. And like right now, I'm kind of lost for words because I have so much to say. And all the memories that I have of my baby are just a few pictures. Because all the recordings and the music that she did, she loved Etta James, Motown, classics like that, that had videotape that were at the house, and I have none of that at all. At that time, I was living in Hardin, Montana. And I wanted my baby to come out there. I lived down the street from Crow Agency, Montana. It's a reservation for the natives, and wild horses ran wild, and she loved animals. She loved insects. She knew and understood the food chain. She wouldn't let you kill a fly. Because that fly could land in the spider web and feed the spider. That's how my baby was. And I knew it was too good to be true. Because people that great don't get to be on this earth that long. The good ones always got to go. For absolutely positively no reason at all. My wife, TJ, or Jade, or Jordan, the last one, absolutely, positively nothing to her. I helped raise her kids. For their stuff, college. Teach her son DJ how to cook. Played basketball together. We worked out together. You know. And Jay loves her. Brittany, DJ, and Ladarius. And to this day, I'm still pondering why. But my dad told me, he says, son, don't try to make sense out of nonsense. And that's what I go by. And I miss my baby so much. Times when I'm at work, I work for a meat packaging company called John Morrell. And if it wasn't for that job, I really wouldn't know where I would be at because it keeps me busy. 11 hours a day, 7 days a week. Because I don't do what I want to do. Just horrible. In regards to anything, nothing in this world is ever going to bring my baby back, and nothing anyone could ever reclaim her. And then my son Jordan, he's gone because of it. And at this point in time, I feel like it's kind of my fault because I introduced this person to my family. So I kind of feel like it's my fault because I never had any discrepancies or any problems. So I just thought everything was kosher. Lived in Montana, was gone for maybe a year and a half total. It's out of nowhere. Why? What? I'm not even here. I'm working 2 jobs to support Brenda and her kids. What did I do to deserve that? What did TA do to deserve it? My baby Jade do to deserve it. I think every day I was looking so forward to my baby going to high school, and he used to go shopping all the time. And Jade, she never cared about names. Yeah. And she only cared about her family and music. She really loved me a lot. She was going to miss her so much now, but I have no other words to say. I don't have words for people like that at all. I just came in to speak on behalf of my family and my loved ones. Thank you for your time.
Thank you, Mr. Morris. Mind your step, please. We have one additional speaker, Mr. Morris's mother, I believe. Ms. Morris, would you like to do the same? Just be standing for just a moment, just be sworn.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? May the speaker please state and spell your name for the record?
My name is Brenda Williams, B-R-E-N-D-A, Williams, W-I-L-L-I-A-M-S.
Ms. Williams, whenever you are ready.
Morning, everybody. I just want to thank God for blessing me today to live to see this day. As far as I'm concerned, this is the day of Jade's funeral. This is the day when we seek justice, and this is the day that she is going to be resting in peace. That horrific crime that was committed against her for unknown reasons. God only knows. And as far as I'm concerned, today is the beginning of the end. We love her. We miss her. Life is never going to be the same without her. We're never going to forget her, and the pain never stops. All I can say is, God rest your soul, Brenda. God rest your soul. There's nothing in this world that she could have ever done to deserve what you did to her. I just want to let everybody know today is Jade's day, and this is the day she's going to finally rest in peace. Thank you.
Thank you, Ms. Williams. Let me give you a moment to take your seat. It's incredibly difficult, actually it's impossible, to reconcile the person that was described by Mr. Oram and the person that this family knew with the person who, in fact, did this unimaginable act, committed this horrific crime. And there's nothing, obviously, that can be done that would change what has occurred. I don't know if these sentencings give the kind of closure that Ms. Williams expressed. I do know that Mr. Morris has no reason to be feeling fault for anything. There's one person who is at fault for what occurred here and the complexities of what transpired to create that person and that circumstance. No one can fully know or comprehend. What I do know is that we can give closure to this matter today, and we will give closure to this matter today, and what occurred through Ms. Stokes entering a guilty plea. And yes, I know that there was a circumstance in which the court had to consider whether or not that plea could or should be withdrawn, and the court determined it could not. But through that plea entry and through coming here today for sentencing, there was not the need for a trial. There was not the need to see horrific photos and horrific evidence of the last moments of and the end of Jade's life. What is so profound to this court today is that Jade lives on the way she does in the memories of the people who loved her and cared for her, and the obviously bright shining star that she was, and that all we can do today is find the justice in the outcome of the sentence, and hope, as was stated by one of our speakers, I believe Ms. Jones, that Ms. Stokes will do whatever good she can with whatever the remainder of her life is, which will be spent in prison, to again, bring this matter to an end. It is this court's determination at this time to follow the negotiations and to sentence and adjudicate Ms. Stokes. Ms. Stokes, the opportunity was already given for you to say something. This is not the time for you to speak. If you are to be speaking at any point from this point forward, it will be through written motion and through the assistance of counsel should one be appointed to you. I have given you the opportunity, and I already had indicated that the process here would be that we would hear from the family members last. At this time, it is the adjudication of this court that you should be determined as to count 1, first-degree kidnapping with use of a deadly weapon. The sentence is life with parole eligibility after 5 years, plus a deadly weapon enhancement of a minimum of 96, maximum of 240 years in Nevada Department of Corrections. As to count 2, murder with use of a deadly weapon, you are to be sentenced to life without the possibility of parole, plus a consecutive term of a minimum of 96, maximum of 240 months in the Nevada Department of Corrections for the deadly weapon enhancement. As to count 3, burglary while in possession of a deadly weapon, you are to be sentenced to a minimum of 72, maximum of 180 months in the Nevada Department of Corrections. Count 3, consecutive to count 2. Count 2 would be consecutive to count 1. I believe I neglected to state that. As to count 4, attempt murder with use of a deadly weapon, you are to be sentenced to a minimum of 96, maximum of 240 months in the Nevada Department of Corrections with an equal deadly weapon enhancement of a minimum of 96 months, maximum of 240 months in the Nevada Department of Corrections. The sentence in count 4 to run consecutive to count 3 in the prior counts. And as to count 5, mayhem with use of a deadly weapon, you are to be sentenced to a minimum of 48, maximum of 120 months in the Nevada Department of Corrections, consecutive to prior counts, with the deadly weapon enhancement equal of a minimum of 48, maximum of 120 months in the Nevada Department of Corrections. As one of the sentences is life without the possibility of parole and the others would subsume the others, I don't believe I need to state a full aggregated sentence. I think the life without the possibility of parole overrides that. If we do need to have an aggregate sentence, I trust that it will be included in the judgment of conviction that the clerk's office prepares, as Ms. Wilson at this time will spend the rest of her life in prison. I want to thank everybody for their efforts in this matter, and the only remaining statement the court has to make is that there is credit for time served. Ms. Wilson has been incarcerated, according to our records, since December of 2012, which is a total of 1,243 days credit for time served. There is also a $25 administrative assessment that would need to be paid by all defendants, as well as the $150 DNA analysis fee and $3 DNA collection fee. The fees will be imposed. The credit for time served will be applied. And this matter is closed at this time. Thank you all. Page 8. I have top of page 8. I have State of Nevada versus Emma McGrath. This is a revocation matter, but I understand Ms. McGrath also needs to proceed down to arraignment court. So if we can call that matter. Mr. Daskis and Mr. Morris, if you can allow us to proceed with our calendar, we'd appreciate it. This is a public defender matter, the McGrath matter. Do we have the public defender present? Do I have any public defenders in the room? Ms. Romney, is that your file?
It's not there.